Hello everyone. Let us take a few minutes to review for the final exam. The purpose of the final exam is to test your knowledge and mastery of the learning objectives and key terms and concepts in weeks 5 through 7. The final exam will include a total of 35 questions, 30 multiple choice and true-false questions, and 5 essay questions. The final exam will be based on the required readings, supplemental readings and lectures, presentations for weeks 5 through 7. The questions will be in the form of true-false, multiple choice, and essay questions as stated previously. Select the most correct answer to each question unless a specific question instructs you to do otherwise. Unanswered questions are counted as incorrect answers. Your response to the essay questions should be a minimum of 250 words and be supported by at least one reference from the readings or outside sources. The final exam must be taken the first time it is launched or opened. It cannot be saved and resumed later. This is not a timed exam. However, you should allow an uninterrupted 2 to 3 hours to answer all the questions. Unanswered questions are counted as incorrect answers. This is an open book exam. Let us take a look at the essay questions. The first question you will see on the exam will be the essay question, will be the Colby contract question. The Colby contract is a breach of contract situation. You will want to discuss what a brief breach of contract is and what constitutes a breach of contract. If I contracted to buy a cell phone from Beth and Beth agreed to pay me $12, or I agreed to pay Beth $12 for the cell phone at a later time, then I have entered into a contract with Beth. There is a valid offer, an acceptance, and consideration. Let's say that I decided later that I've changed my mind, and I told Beth I changed my mind. But then I decided at another time that before the date of the contract, that I want to actually buy the cell phone. And Beth is refusing to sell the cell phone to me. Then Beth has breached the contract simply because I agreed to buy the cell phone changed my mind within the time that we were supposed to enter into the contract. The only way Beth would have avoided a breach of contract is if she had decided to do an anticipatory breach because of my anticipatory repudiation of the contract. So here you want to discuss these 3 terms that you're seeing on the slide and discuss how this affects this scenario. I can, of course, retract my repudiation of the contract at any time before the performance is due. As long as I do that, then Beth is obligated to sell the cell phone to me and abide by the terms of the contract. Now let's look at the next question, which is the Best Products Inc. question. Now, with this question, this question is asking about an e-commerce strategy for marketing best products. Cole signs a contract that includes a clause prohibiting him from competing with Best during and after the employment. Before the strategy is implemented, Cole resigns from Beth's employs and opens a business to compete with Beth. In the Beth's suit against Cole, you want to discuss the most important factor in determining, which is determining whether Cole could compete with Best. In determining whether Cole could compete with Best, you want to take a look at the covenant not to compete. Discuss this in detail and discuss the elements that surround this covenant. A covenant not to compete may also violate public policy to promote competition in the economy. So when discussing this covenant, you also want to examine public policy as it relates to the Cole and Best issue. Now, if it does violate public policy, it would be an unreasonable restraint of trade. So take a look at that as well. Now, to be enforceable, a covenant not to compete should be ancillary to an otherwise enforceable contract, which, in this question, is the employment contract. The restriction in the covenant not to compete should be reasonable. It should, in terms of its terms of duration and geographic areas. So, for instance, if a covenant not to compete has a duration of 10 years, that may be considered unreasonable. If it says for all geographical locations within the state of Georgia, that could be unreasonable as well. However, if the contract states within the Atlanta metro area, then that may not be deemed as unreasonable. If the restrictions are unreasonable, a court can void or reform the covenant. Whether a party resigns under an employment contract does not affect the enforceability of the covenant not to compete. So take those factors in mind when you're discussing the Best Products, Inc. question. The next question deals with the Carl's Hardware Store. This is a strict liability case, and you would want to discuss the elements of strict liability. In an action based on strict liability, a plaintiff must show that 1. The product was defective. 2. The defendant was in the business of distributing the product. 3. The product was unreasonably dangerous due to the defect. 4. The plaintiff suffered harm. 5. The defect was the proximate cause of the harm. And 6. The goods were not substantially changed from the time they were sold. These are the elements of strict liability you would want to consider when answering this question, and apply those elements to the fact of your case to determine the strict liability here. A plaintiff does not have to show that there was a failure to exercise due care, and this distinguishes an action based on strict liability from an action of negligence where the requirement of due care is necessary. In strict liability, the requirement of due care is not necessary. Now, if Bob establishes his case, the court in this problem is most likely to rule in favor of who? You need to answer that question. You need to determine whether the manufacturer was strictly liable under the circumstances. Strict liability, also remember that strict liability allows a plaintiff to recover damages for injuries resulting from product defects without any proof of fault. So take these factors into consideration when you're discussing the Carl Hardware Store question. The next question you have is a two-part question. The first scenario, you're looking at acquiring title and how that title was acquired. A buyer acquires title whenever whatever title the seller has to sell the goods. So if I had good title, then you, the buyer, would acquire that good title when you're trying to buy the goods. If I had bad title, then you would acquire that bad title. If the seller is, let's say that I stole the product, then the seller's title is void. So my title is void. I had no title. Thus, a person buying a product from me who would have stolen the good can not acquire title. And the real owner, who the item was stolen from, then has superior rights. So you want to look at how the property was acquired, whether the person that acquired the property, the person that was selling the property, had good title to begin with. And if that person has good title, then they would pass good title down. If they didn't, then no title is passed. And the owner, the real owner, has superior rights. The second scenario then we're looking at, again, the title issue and entrustment of goods. So when a person entrusts goods to a merchant, that's the person who deals in goods of that particular kind. The merchant has the power to transfer the good title to any purchaser who acquires the goods in the ordinary course of business. So remember that the merchant has good title when they acquire it. So if the person, so let's say then that I entrust my cell phone to Cell Phone Inc. Cell Phone Inc. is in the business of selling cell phones. So then they're the seller of goods of that kind. Therefore, Cell Phone Inc. then passes good title to customer Brent, because Brent purchased my cell phone in the ordinary course of business. Then Brent can in turn go and sell back my cell phone because he got good title, because he got it from Cell Phone Inc., who got title from the true owner, and then equivalent title was passed. So these are things you want to look at as you consider the television scenario. Now let's take a look at the Quality Auto Sales Inc. sales question. You will be answering the question of whether Quality transferred the right to receive PAM's payment in an assignment to Rapid. The parties in an assignment are the assignor and the assignee and the obligor. So you want to make sure that you discuss these three parties when you're discussing an assignment question. The party originally entitled to payment of the money is the assignor. Who will that be in this case, in this scenario? The party who agreed to pay is the obliger. Can you look at the scenario and see who that person might be? And the party who receives the right to the payment is the assignee. The obliger's consent is not necessary for an effective assignment. On an assignment, the rights of the assignor are extinguished, and the assignee has a right to demand performance. The assignee takes only those rights that the assigner originally had, however, subject to the defenses that the obliger has against the assignor. So, whether you should answer the question here, whether Quality fraudulently procured the right of PAM's payment, and whether PAM can raise this fraud as a defense against payment to Rapid. This is the end of those essay questions. I wish you good luck on the final exam. My suggestion is that you download the questions from the Week 6 folder and work on those questions before entering the final exam. Save the answers on a Microsoft Word document. This will give you the opportunity to research the answers to the questions. You can then cut and paste your responses into the box when you open the final exam to complete the multiple choice and true-false questions. Remember, your responses to each essay question should be a minimum of 250 words and be substantiated by at least one reference. Good luck with your final exam.